So by a vote of 7-2, the Supreme Court has said that the president is not absolutely immune from a state grand jury criminal process. The court does not seem that concerned about the second prospect the president raised about harassment from district attorneys across the country who are politically elected harassing the president. By a 7-2 vote, the Supreme Court has ruled in favor of the district attorney, Cyrus Vance. We're looking through the opinion here to see whether there are any further restrictions on this, whether this has to go back to a lower court. But this is a victory for Cyrus Vance. Now, that does not mean so the court is saying the president does have the authority to challenge specific subpoenas that deal with the office of the president if any of what the grand jury wants touches on his official duties. But remember, the bulk of what the grand jury is seeking here in this case is material and business records that pertain to matters before he became president and that don't pertain to his official duties. Now, that doesn't mean that we're going to see these tax returns. What it means is that the president's accountants must turn them over to a New York grand jury. Under New York laws, as indeed the laws of many other states, grand jury proceedings are secret. So the material can be turned over to the grand jury, but it could be that we, the public, may never see them. The only conceivable way, I would think, that we would ever see these records is if the New York grand jury's investigation leads to some indictment of someone in the Trump organization, and that goes to trial, and those tax returns become evidence. What the Supreme Court is doing here is sending this back to the trial court to let the president try to see if he can narrow the circumstances of this subpoena. So these records are not going to be turned over to the grand jury immediately. So, let's just back up here for a second. Right. Number one, the president cannot, there's no categorical bar. He cannot say absolutely no to Cyrus Vance. Secondly, this goes. So I'm just right. Hearing a little more about what this case may portend for the second case that we'll get in 6 minutes about the congressional subpoena. It sounds like the Supreme Court is saying in both cases that the president cannot say, I'm absolutely immune, I can't be bothered by these subpoenas. So in the first case anyway, they're sending it back to the lower court for the president to kind of duke it out with Cy Vance to see whether the subpoena can be narrowed in any way, but he can't categorically absolutely say no. He has to go back into court and play ball with the New York district attorney. The two arguments he's made so far are now dead letters. The idea that he's absolutely immune from any part of the criminal process, including grand jury subpoenas, that's a dead letter. So is his claim that he could be harassed by local prosecutors. So now the question is, given that he's the president, given the sensitivities of his office, can he narrow this subpoena? So we'll have to see what they say about the congressional subpoena, but it sounds to me like they're foreshadowing, in this opinion, the notion that the president is also can't categorically say no to Congress. And it may be that what the Supreme Court does in the second case, which we'll get here shortly, is to say something similar, that maybe there's a way to narrow these subpoenas, because several members of the court during the argument did seem to be concerned that the congressional subpoenas were overbroad.
Thank you for checking out our YouTube channel. Why don't you subscribe? It's really easy. Just click on that button down there. And for more news from MSNBC, click on any of these videos here for the latest interviews and highlights. You can get more videos from MSNBC with our newsletters. Head over to msnbc.com/newsletters to sign up.